Before we begin with the first technical session of the TIOL Tax Congress 2023, a big thank you going out to our state partner, the state of Rajasthan, for all its support to the TIOL Tax Congress. Can we have a huge round of applause for our state partner, please? And now, ladies and gentlemen, the first technical session, which is all about income tax, international taxation, and corporate tax. Now, with the ever-evolving landscape of international taxation, it is imperative for businesses to navigate through the complex tax developments. A panel of experts will share their insights on the tax and regulatory landscape from policymakers, taxpayers, and professionals' perspectives. Ladies and gentlemen, please join me in welcoming onto the stage first the anchors of the very first technical session of this Tax Congress, starting with Mr. Pramod Kumar, former Vice President, ITAT. I request the anchors to please get seated on the extreme left or the extreme right of the stage. Thank you, Mr. Pramod Kumar. The panel will also be anchored by Mr. Sandeep Chaufla, partner PriceWaterhouse & Co. LLP. A very warm welcome to you, Mr. Sandeep. I request you to take the seat on the corner, please. Thank you. And I'll keep the applause going as we request our esteemed panelists to join us on the stage, starting with Mr. Akhilesh Ranjan, former member CBDT and advisor PriceWaterhouse & Co. LLP. Mr. Kamlesh Varshney, member SEBI. Mr. Pratap Singh, principal CIT Gurugram. And Mr. Dhiren Shah, Senior Vice President, Taxation, Adani Group. Thank you, gentlemen, for making time for the TIOL Tax Congress. Over to the anchors for moderating the session. Can we have the mics on stage, please?
Hello, hello. Very good morning, friends and colleagues. We had a very interesting opening session of the TIOL Congress where Justice Maheshwari talked about how the whole system of taxation evolved in the world, particularly in India. Starting with Manu Smriti and then getting into Arthashastra at the Chanakya era. And also, very interesting historical facts as to how the law has evolved. As the societal demands grew, that's how the evolution of law has happened, including the tax laws. And then Justice Gupta also dwelled upon some of the very key aspects of any fiscal statutes, which still underpin the taxation system in the country, even today, even after so many years of evolution, which is tax certainty, the literal interpretation being the hallmark, unless and until there is any ambiguity, and reasonableness of taxes. Now, as the law evolves and has evolved over the years, and it will keep on evolving, taking cue from what my colleague Gautam said, that change is the only constant, and disruption in today's time is seems to be the only constant. So tax systems also, keeping in mind the various changes which are happening, the fast pace in which the society and the economy is changing, it has become global. The tax systems have also changed, and and which is an ever-growing thing that we see. Now, friends, the topic for the day is on international taxation and tax certainty, and some of the initiatives that the government has taken to reduce tax litigation and in the whole realm of tax reforms. Starting with beneficial ownership, which is a concept that we see in the tax treaties, particularly Article 10, 11, and 12, that is dividends, interest, and royalties, and fee for technical services. Now, this is a concept which has been there in the tax treaties, in the OECD model, in the UN model, as well as in the US model. However, there have been various interpretations of that, both in India as well as by the overseas courts, something which the taxpayers and the judiciary has grappled with. So we will discuss about the whole concept of beneficial ownership, how the law is evolving, what is the view, what is the policy view on beneficial ownership, and then the whole issue on the tax residency certificate, the TRC. Starting with, we had the landmark judgment of the Supreme Court in Azadi Bachao, delivered in October of 2003, followed by Vodafone, and then, with some hiccups here or there, many tribunals and the courts have followed that. And now we have the, pursuant to the MLI, the principal purpose test in forming part of the treaties, wherever the countries have signed the MLI. And then we get into the very important aspect which I touched upon, which is the tax transparency, the tax reforms, and which is faceless assessment, faceless appeals, measures taken by the government to reduce the tax litigation. So these are the some of the things that we will discuss in the next 45 to 50 minutes. I'll request my co-anchor, Shri Pramod Kumar ji, to maybe lay broader contours on the topic, and then we will start with the Q&A with the panelists.
Thank you, Sandeep. I shouldn't come in the way of this discussions, and we have some. Thank you, Sandeep. I'm sure all of you are waiting to hear these very eminent panelists we have today. Kamlesh is there, who has played a key role in forming tax policy in last 1 decade. Then you have Mr. Ranjan, who has also played a very key role in CBDT. Many of the legislative developments you see today are the developments which were initiated during his period. Dhiren is here to give industry perspective. And then we have with us Mr. Pratap Singh, Principal Commissioner Income Tax from Gurugram, who is to give a very interesting perspective about tax reforms and how things have changed during the recent years. Talking about beneficial ownership, which is the first topic, I think without a strong beneficial ownership on the first principles, your treaty with one country becomes a treaty with the world. So to say that you don't need a beneficial ownership would probably be a definite understatement. At the same time, a too overzealous an interpretation and an approach does upset what are standard practices, how the trade has developed over the decades, and it does affect the tax certainty, which is surely has a very, very key role to play in business atmosphere. Unfortunately, by and large, so far the beneficial ownership clauses, the way they have been interpreted in India, this is all about the timing test rather than substance test. And if I can say so, the courts abroad they have only touched the surface of what the conceptual background of this issue is. In India, we had very few cases. The higher judiciary is yet to look at it. And in the recent years, Income Tax Department has taken a very, I wouldn't say aggressive, but a very comprehensive approach. And that is inevitable because once we realize that the aggressive tax planning is no longer flavor of the season, it's only compliance and it's scrupulous compliance and a reasonable approach which will beget reasonableness. If you have any lesson to take from what has happened in tax administration in the last 1 decade, the lesson is you have a tax administration which is very responsive to your needs, which has amended its course wherever required to facilitate your business, to do whatever best they can do. But at the same time, they are quite aware about what the correct legal positions are, and they are ready to stick their neck out wherever required. On beneficial ownership, unfortunately, the decisions we had from some jurisdictions, notably Canada and some European jurisdictions, as I said, they were touching the surface. But recent decisions from a couple of countries in Europe and also from elsewhere in Asia, they have given us food for thought. And I'm sure these discussions, as we discuss it, and particularly with the presence of the eminent panelists, we'll dive a little deeper into this and understand the government perspective also, and to take a holistic picture rather than being superficial and living in dark. Then the other issues regarding 10F, I wouldn't, rather than talking about these issues, I think we should start with our discussions on beneficial ownership. Sandeep, if you can go ahead with your questions.
Thank you, sir. So, as Pramod sir said, the concept of beneficial ownership in the Indian context, the judicial decisions that we have, they have, only scratched the surface. And they have principally gone by the context of beneficial ownership, and it's a term which is not defined in either of the model conventions or even in the Income Tax Act. Now, the model commentary, the first time in 1977, laid out that beneficial ownership would be denied where the recipient is either an agent or a conduit or a representative. And then in the subsequent commentaries of OECD, there have been, more variants of these terms only, with the result that where the recipient of an interest, dividend, or royalty, the passive incomes, has been said to have the right to receive that and use those monies in its own right, even though there may be back-to-back arrangements for passing on those passive incomes to its shareholders or the further licensors, as the case may be. Predominantly, the decisions from the Indian courts have been in favor of the taxpayers to say that the beneficial ownership test is met, and therefore the reduced rate of tax as per the treaty should apply. Now, the Canadian Supreme Court, now Canada is not a popular word these days in the Indian context, but yes, the Canadian Supreme Court in Provost way back in 2008 had also laid down on a similar basis, followed by Velcro, again a Canadian Supreme Court. But as Pramod sir said, the spate of judgments which have come in from the European courts have sort of being seen to move the needle more towards on the substance side of it, to say that, should we be restricted in looking at beneficial ownership only, that is there a contractual or a binding obligation to pass on these passive incomes to the shareholder or the next layer, or if in substance you are anyway passing on those income streams to the shareholder or the next stream of company, should the beneficial ownership test be said to not have been satisfied? So therefore, my question to you, Akhilesh sir, is that given all this background, the Indian context in a limited sense, as Pramod sir said, whatever the Canadian courts have said, and some of the judgments which have come in from, say, the Swiss and the Argentina High Court day before yesterday delivered a judgment, where they now seem to be more looking at the substance side of it and not restrict them only to the contractual kind is the policy at the policy level, and also which way do you think the wind is blowing?
Yeah. Thank you, Sandeep, for that very important question. I think this is an issue which is taking the tax world by storm at the moment. Litigation not just in India but also overseas, as Mr. Pramod, Kumar and Sandeep have mentioned. It is something which is now increasingly as a factor in trying to achieve tax certainty, which is the theme that we all are interested in. But before I start answering, let me express my gratitude to TIOL and to Shailendraji for inviting me here. It's a pleasure, as always, to be part of this Congress. So I think it's very right to say that jurisprudence is evolving, domestic as well as international. And I think it might take some time for that jurisprudence to settle down, to lay down clear principles. There are ways and ways of defining beneficial ownership. There are definitions in the context of FATF, of different laws, but a definition in terms of the tax treaties is something that is still very, very unclear. And so I think it's important to understand the policy perspective as to what does it mean really, how does it find a place? And I would just like to come back for a while from case law and judicial opinion and to see what treaties are all about. Tax treaties, as you all know, are means of allocating taxing rights. A treaty does not decide how or whether some income should be taxed. It decides where that income needs to be taxed. It takes as a fundamental principle the primary rule of residence-based taxation and then allocates taxing rights to source jurisdictions in certain limited circumstances. And that's the essence. It's essentially trying to carve out source taxation rights from the omnibus residence-based taxation rights. And in this scheme, then, we have this Articles 10, 11, 12, which deal with dividends, which deal with interest income and royalties, which have a place of their own. And these are the articles which talk about, which mention specifically beneficial ownership. Now, why are these articles mentioning beneficial ownership is the first thing that we must talk about. These three items of income are essentially mobile incomes. You can move this income to any part of the world with great ease. Income from dividends, you can only have to invest in equity capital. Income from interest, you only have to move funds or capital into that jurisdiction. And royalty, you only have to move an intangible, which all extremely mobile. There is no need to shift businesses as such or brick and mortar industry into those jurisdictions. And because it is so mobile, the treaties then say that, all right, they lay out a rule, which first of all starts with the primary rule of residence-based taxation, that even for these articles of income, it is the primary right is with the residence state. Then it says that the source jurisdiction will also have a right to tax. I'm using the word also in a loose sense. I know there are many judicial views on whether it's also or may or whatever. But from a policy perspective, from a tax administrator's point of view, the source jurisdiction also has a right to tax this income. And then there's a third component which places a limit on the extent to which the source country can tax it. And that's why this concept comes in. Because the income is so mobile, there has to be some sort of way in the article itself to say that, look, the benefit is meant for residents who are not just residents in the sense of Article 4 of the tax treaties, but are also people who are actually intended to be benefited by the tax treaty. There is no mention of beneficial ownership in Article 4 dealing with residents. Residence is an entirely different concept. You can be incorporated in a place and be a tax resident of that place. But beneficial ownership is what the tax treaty negotiators had in mind when they started negotiating these articles. And then, so therefore, the benefit, if at all, of this lower withholding tax rates is intended for those people who were intended to take the benefit of the tax treaty. Not just because they were incorporated in that place, but because they were actually what the governments had in mind when they wanted to promote their trade and industrial relationships. So I think it's from that point of view and that's the reason I think why judicial thinking is still evolving. You can't go by rule of thumbs out there. You can't just say, okay, beneficial ownership means that you have the right to decide what to do with your income. That's not enough. You may have the right to decide what to do with your income, but if the intention of the treaty is not, or the object and purpose, which is a qualified term, or the object and purpose of the treaty is not to give that benefit to the entity or person in this source jurisdiction or to the resident jurisdiction, then the mere power or authority to deal with that income may not be sufficient, may not be adequate. And that's I think, the background in which we must proceed with this. I entirely agree that if we keep these principles in mind, then what we're talking about is substance, actually. Who was it that the treaty is meant for? Is it meant for anyone who incorporates in that country, or is it meant for people, industries of that country with whom the other country has a trade relationship? And that's the thing which is difficult to define, difficult to achieve, but that's where we must all, while making our decisions, think and factor in while taking any decision as to where exactly is the benefit intended to lie. And then the other, of course, things can follow later on, but the primary principle must remain that, I think.
Yes, sir.
But that takes us to a very interesting question, and I think I should ask Kamlesh that question. You are talking about the beneficial ownership provision where it's specifically mentioned, but there are situations, for example, in Article 13, where beneficial ownership is not mentioned, yet is inferred. And we have also seen just about a year ago when Canadian Supreme Court had a 4-2 decision with the Chief Justice in minority on this question of implicit requirement of the beneficial ownership. Now, there is a school of thought, and I would think it's a valid school of thought considering how the decisions from European jurisdictions have come now, that whether you specifically put this in a clause or not, beneficial ownership requirement is one of the very fundamental ingredients of the foundation of the treaty network. You know, otherwise, as I said, as I began by saying, one treaty with one jurisdiction becomes your treaty with the entire world. We are living in a world where capital is so mobile. We have seen how capital gains have all shifted to Mauritius. So I would ask Kamlesh to give his perspective about the implicit requirement of the beneficial ownership, and how do you see this beneficial ownership as one of the foundation stone of the treaty jurisprudence?
Thank you, sir. And once again, my gratitude to TIOL, Shailendra ji, and everybody giving me an occasion to be here, and extremely privileged to be part of this panel. I've worked with Akhilesh, Ranjan sir, and Pratap is my batchmate, and we have learned income tax reading Pramod Kumar sir's order. So it's really a privilege to be here. I have removed my nameplate because it mentions CBDT, and I just want to clarify that, I'm not a nominee of CBDT, so CBDT is not my beneficial owner. So I just want to clarify that. Okay, and, but even if I was, in CBDT, it doesn't matter. Whatever views we express, so I can put that disclaimer on behalf of my batchmate Pratap Singh, that whatever he's going to say will not be the views of the income tax department, that will be his personal views. So that has always been the position of all government officers. So, with that disclaimer, a very interesting discussion that we have about beneficial ownership. One thing we need to understand, the question is that beneficial ownership is specifically mentioned in 10, 11, 12, but not mentioned in Article 13. So let us take an example. I am paying dividend to a company in X jurisdiction, and the question is whether Indian treaty with that X jurisdiction would apply to have a reduced rate of dividend taxation, because the person to whom I am paying that dividend in X jurisdiction is not beneficial owner. Beneficial owner is sitting somewhere else. So I am prevented from applying India X jurisdiction DTAA. So is it logical that you are prevented from applying India X DTA on dividend taxation, but you allow that India X treaty for capital gain taxation? Share is same, whether you receive dividend or whether you receive capital gain. it is the same people who are owning the share beneficially or on a nominee basis. So the point that Pramod Kumar sir mentioned, that whether beneficial owner is specifically mentioned or not, does it really matter? And the way jurisprudence is moving in Europe, that's something very important to consider. What Akhilesh sir also mentioned, something very important, that ultimately we are moving to substance over form. And when we talk about substance over form, Sandeep spoke about the journey of DT OECD commentary. Now, if you read that OECD commentary, it clearly says that anti-abuse rule is all pervasive. If you read the commentary of Article 1, it clearly says that benefit of treaty is not to be given if it is shown that the purpose was, there was no commercial rationale for that business transaction, and the only, or the purpose was only to obtain tax treaty benefit. I know people will say that has only come in after BEPS, principal purpose test, has come in only after BEPS, but OECD commentary clearly says PPT or no PPT, because PPT is in Article 29. Now the revised commentary clearly says PPT or no PPT, anti-abuse rule is all pervasive. That will apply. So it doesn't matter whether PPT has come into our treaty with Mauritius or not. OECD commentary clearly says that anti-abuse rule always applies. And therefore, now that I am outside the department, I can actually present both the pictures from both sides. The Blackstone judgment, in my view, is a correct judgment. 148 should not have been done in that case. But there was no need, probably in my view, there was no need to even examine whether beneficial ownership is there in Article 13 or not, because the issue was only 148. From department side, I feel that department should have invoked anti-abuse rule if it wanted its case to be stronger. And that is where department should move in future, invoking anti-abuse rule where there is absolutely no dispute, while beneficial ownership, to what extent beneficial ownership is satisfied or not, there would be jurisprudence. Whether beneficial ownership applies to Article 13 or not, there would be jurisprudence, and European courts will move in one direction, and our court or Canadian court will move in another direction. But if you invoke anti-abuse rule, then there is only one direction for court to examine whether that rule was correctly invoked or not. From taxpayer perspective, also, my suggestion is that instead of concentrating whether it is, whether we satisfy the test of beneficial ownership or not, please ensure that your structure has a business rationale, commercial rationale, rather than, seeing that Mauritius Treaty does not have PPT, so I am saved. That is not the case. Thank you.
Thank you, sir. I think these are very important inputs. So just one thing which comes to mind, excuse me. If we look at any of these judgments, and sorry, I'm again going back to the jurisprudence, starting with Azadi, then followed by Vodafone, they moderated Azadi to an extent by laying down those things, and Blackstone, which you rightly mentioned, Delhi High Court. Now, the one common theme going through all of them was Circular 789. The TRC, whether the having a TRC, whether that's sufficient or not. And if we look at 789, the CBDT circular itself, it has three paragraphs. Paragraph 2 and 789 deals with both dividend and capital gains. On dividend, paragraph 2 says that TRC will be a sufficient evidence for test of residence and beneficial ownership. Paragraph 3, which talks about capital gains, only talks about test of residence. So, therefore, sir, do you think, though, what you said that, yes, even if it is not there, even if in Article 13 beneficial ownership word is not there, and leave aside the Canadian decision that Pramod Kumar sir referred to, ELTA, and contrary judgment incidentally came yesterday from the Korean Supreme Court, saying that even if it is not there, you have to read that into Article 13. Leaving those, foreign judgments aside, but we have got our own Circular 789, clearly distinguishing between Article 10 and Article 13. So how do we deal with, as taxpayers, the points that you mentioned on substance or form clearly are there. These are the cornerstone, no doubt about it. But how do we deal with a situation like this, sir?
So my question would be, just because Circular 789 uses different phrase in 2 different paragraphs, can we conclude that, it is a view of CBDT that beneficial owner tax will not apply for capital gain? Can we say that? Maybe the thought process is that, I'm not giving exemption from beneficial ownership from capital gain. No, that interpretation could also be taken. That is point number 1. Point number 2 is that there have been cases where courts have said that circular cannot go beyond the law, even in giving concessions. There is indirect tax. Shah sir is there. When I was under secretary, I remember at that time the judgment came that they say even giving relief to taxpayer, you cannot go beyond the law and cancel that circular. Though we also have some other, decisions where, courts have said that, okay, fine, this is beneficial to the taxpayer, so I am not going to interfere. But there have been cases of Supreme Court.
Yes.
So that is, one extreme, one view. And I am not even taking that view. I am only saying that 2 interpretations are possible of that circular. How are you so certain that because CBDT has used only one terminology with respect to Article 13, that means I will conclude that CBDT view is that beneficial ownership does not apply to Article 13. I think that will be difficult to, take a view.
I want to just add one point. Practically, I agree with that clause 10, 11, 12, and where the concept is applicable. And now with the MLI and PPT, etc., it's quite crucial also. But as a payer, when I do a payment of any FTS or a dividend, how would I know that what is the ownership of that company, or who is the substance is there or not? As a payer in India, how would I know that? And because I am paying to a country where I don't have any visibility, what should I do, sir?
Yeah, so this is
Yeah, practically,
you have raised a very
day in, day out, sir.
No, you have raised a very practical issue, and I completely agree that there is no clarity on this aspect. Let me give you a international perspective. International perspective is that tax treaty applies only at the time of assessment, not at the time of withholding.
Correct.
So far as withholding of taxes are concerned, normally, internationally, I am not supposed to look at tax treaty. Though in India, it's a different position because 237A definition of rates in force, we have given benefit of tax treaty, and therefore, the deductor would rightfully claim that, no, I have to look at tax treaty. That's a concession given by India, which is beyond international obligation. Perfectly fine what you are saying. But if you have to give benefit of tax treaty at the time of withholding, you are required to check beneficial ownership. And if you have a doubt, then it is better that you withhold at a higher rate than at a lower rate. That's a normal position. But you can say that CBDT has not enforced that position because at the time of withholding the certificate that we get, we still, there is no clarity that how I have to satisfy beneficial ownership test. And that is one thing where, future work needs to be done. And because it will require more, compliance on deductor, therefore, my guess is that, that may be something which CBDT may be considering, and that is why not coming out with clarification at this point of time. But this is something definitely is a work for the future.
Because practically when we say that we want to do a higher taxation, counterparty always comes back and say, then the additional tax is on you. You bear the taxes. It is a factual issue and we face it day in, day out.
Yeah, sure.
Thank you. Sir, moving on to Akhilesh, sir. Sir, now with PPT being there, after signing of the MLI, A question arises that if a taxpayer, and let's say for the sake of discussion here, restrict ourselves to dividend, those passive incomes, 10, 11, 12, where a taxpayer has satisfied the beneficial ownership test, does he still need to satisfy the PPT in the sense that what is the interplay between the PPT, the principal purpose test brought in the tax treaties or to be read in part and parcel of the tax treaty because of the MLI and the beneficial ownership? Is it that these are once one test has been satisfied, am I through? Or is it that in addition to the beneficial ownership, I also have to satisfy the PPT?
I think I'm quite clear in that view that they are entirely independent. The mere fact that you satisfy a beneficial ownership condition for 10, 11, and 12 does not mean that the PPT rule or the general anti-avoidance rule does not apply. As I was mentioning earlier, when I first made some comments, while examining beneficial ownership, one has to go beyond things like residence or place of incorporation or entitlement to a treaty. One is required to go into the object and purpose. And that thought, that concept, which was not stated earlier in a treaty anywhere, has now been stated in the form of the principal purpose test. It was always understood, as Kamlesh was saying, that whether an article talks about beneficial ownership, whether an article talks about substance or not, the concept of substance is always embedded in every article. And, but then this thought, this concept itself has now been brought into the treaties through the principal purpose test. So, in my view, I mean, one cannot say that if you satisfy a beneficial ownership test, which again is a very hazy concept, when do you satisfy the test, then you need not think of the principal purpose test, because the principal purpose test is looking at a much broader scheme of things in the treaty and looking at whether the benefit is intended to be given to this particular entity in that particular jurisdiction. So I think it's certainly, one can't take it that the two are same, they operate independently. And one can, of course, argue at length on this point. It's a very interesting topic for discussion. I don't think we have the time for that now. But I think PPT rule, which is flowing right through the treaty, through all the articles, is something which is conceptualizing the intent and the object and purpose of all articles, including 10, 11, and 12.
I think the amendment in section 90, the amendment in preamble, these have also changed the ecosystem of the judicial value system. Today, I can tell you that as a member of the tribunal when I was, the constraint is that you have to remain within the framework of law as laid down by the honorable courts above. But today, the very value system inherent in those judgments have changed. In the post-BAPS world, in a world where section 90 is amended, in a world where preamble to treaty is amended, you cannot take the same approach to the treaties which you took, let's say, 10 years earlier. Now, this evaluation of the judicial thought process must also be factored. And when you look at those narrow issues, and we talk about the decisions, earlier decisions, I ask myself the question, if these judges had to take into account the amendment in preamble which we have today, if these judges had to take into account the amendment in section 90 that we have today, would they have come to the same conclusion? My answer is emphatically negative. Now we are living in times when double non-taxation is a strict no-no. We are living in a time where, doing structuring, having a tax shelter only to reduce taxation is a strict no-no. So once the free factor for these, then our approaches also change. And that needs to be taken into account. Now coming to the, can we move to the next portion now? I think we have enough of this, and we can probably, with the kind of panelists we have, so knowledgeable people, they can spend hours talking about the beneficial ownership alone. But we must move on to the next topic. And that is something of the general interest. That is with regard to the requirement of 10S. And what happens to the non-residents who do not obtain PAN and they have to give their TRCs? Now, there are situations, for example, if somebody is selling goods to India and he crosses the threshold of significant economic presence, which is, he has to essentially avail the treaty benefit. But in those cases also they have to obtain PAN. Now this is an issue raised in the industry time and again that this is causing great inconvenience. But I'm sure there must be good conceptual policy reasons as to why these decisions were taken. And particularly now that this 30th September is already over and that initial time limit which was concession which was given has come to an end. So I will ask Mr. Pratap Singh, but before that, because Kamlesh was in policy making at that time and he must have played, I'm sure, a very significant role in framing all this. I must ask Kamlesh, what were the policy considerations?
Sir, Kamlesh will come later, so I'll make a brief announcement, then Kamlesh can take over on this issue. You see this, the time limit as Pramod sir was saying has expired on 30th of September of filing Form 10F in physical form. And it was causing a lot of anxiety among the taxpayers, especially the non-residents. So yesterday I was having a discussion with a person concerned in CBDT, and I'm very happy to share that something positive is coming out on this issue in respect of 10F. And people may be in position to file Form 10F online without going for PAN and all that. So this is very
good news, sir.
Nice and very positive decision. And the modalities are going to roll out soon. And I think now Mr. Kamlesh can take over.
Disclaimer comes to an end now.
And disclaimer, like Kamlesh used it earlier, my personal views, not necessarily of the government view. Yeah, Kamlesh.
I thought audience will be very happy that this disclaimer is coming to an end.
It is happening, sir. It is happening, and very credible news.
Credible good news, sir.
Kamlesh,
Really good news, sir.
expand.
No, I'm outside. No, I have no knowledge. I have left IIS on 20th of September. Pratap is the right person to answer that question, like what is the thought process. To answer the question, what is the thought process at that point of time, I think that has always been communicated because, you know, even though I have left, I cannot discuss things which were discussed internally, but I can only speak about things which are in public domain, and that thought process has always been that if you look at Section 139, then Section 139 mandates filing of return by every foreign company once they have a business connection in India. So, you know, and once you have to file a return, you got to have PAN. And that requirement has been in the Income Tax Act for more than 5-6 years, I think. That 139 amendment was, I think, was somewhere in 2016 or 17. Which was done. So that has always been the case that, you know, if you have a business connection and all, now that is one thing. So either you know, that section needs to be diluted first. Probably what we are trying to do is that we are going to 10F without looking at the main section. 10F is only a procedure that if you want a tax treaty benefit, you need to give 10F. And now, they have mandated, you know, that you should have a PAN for that purpose. But the right, you know, ask from the industry should be to have a relook at 139 once again, whether, you know, every company is required to file return or only those who have taxable income in India, you know, if suppose they are covered by tax treaty benefit and they don't have a permanent establishment in India, so they don't have a taxable presence in India. In that case, they are not required to, you know, file tax return. Then probably things will become more simpler and get aligned with 10F.
Yes, I will come to that point only. In view of this amendment in SEB, anybody who is dealing with India has a SEB implications, right? So in that case, is to have a PAN and to file the IT returns by those companies is quite not
That's what you pointed out.
Yes, sir. So
But
I
Mr.
agree
Pratap
with
Singh,
you on that point, sir.
Just to take that point a little further, imagine a situation that you have a Chinese seller who is exporting, goods to 80 countries. Do you seriously expect him to take PAN in 80 countries and file income tax returns there? And if you think so, what do you think of the Indian exporters who are doing this likewise?
I think this is a very valid question, and a policy decision is to be taken by the Indian government in a global context. So it can't be India alone. So globally, some kind of decision is to be reached. And I think the discussion probably generally there is acceptance to the fact that if a person is doing business in 100 odd countries or 200 odd countries, in how many places he's going to obtain the PAN, just to obtain the treaty benefit. So let's wait for some time till these modalities come out, and then probably we can discuss this issue further.
I think taking on what Pratap is saying, so if you see Pillar 1, now what is going to happen is that even if you don't have permanent establishment in 100 countries where you are doing business transactions, you still have to give some amount of tax as per Pillar 1 calculation. Of course, this is now applicable to only 100 top MNCs groups. But that is coming. That means if you are one amongst the 100 top MNCs in the world who are in scope for Pillar 1, and if you are dealing in 100 countries, doesn't matter, you don't have a permanent establishment in those 100 countries. You still have to, obtain PAN because you have to implement Pillar 1 solution there. So unless OECD or inclusive framework comes up with some kind of an alternate situation, having common PAN or something like that, so that the direction in which the world is moving is asking you to have PAN in all the countries.
The point was not about the 100 top countries. The point was about that seller who is doing business with those countries. They are much smaller in scale. Of course, once you operate on that scale, certainly, as you very rightly pointed out, post Pillar 1 scenario, this will be inevitable. And, talking to you on taking it a little further to the tax certainty point, what is this, remodeling of the Authority for Advanced Ruling? How do you see it contributing to tax certainty, and how do you see it contributing to faster resolution of dispute? This kind of authority for Board of Advanced Ruling now in the place of Authority for Advanced Ruling, both the parties at liberty to file appeals, persons who are manning these institutions are officers working under the CBDT. So can you throw some light about what must have been the policy consideration and what is the object sought to be achieved by this change in modeling of the advanced ruling mechanism?
I will only say, my personal view, now that I'm, what I see the future for the department is that we need to move towards resolving cases. You correctly mentioned that, resolution of dispute is one area which, government has done very well. I have not read Pratap Singh's book, but, I can say, having been part of the government for last so many years and tax policy for last 5 years, that a lot of positive things have happened, and which is reflected in the tax collection growth, the number of taxpayers growth. So things are, happening and happening at a good pace. But tax reform is one thing which is never static. You have to keep reforming. And it is also true that you can't do too many reform at one particular point of time. You have to face those reform over a period of time. So probably now that there is a stability in tax collection and a lot of things have settled down, it is the time to concentrate on how do we resolve cases in APA style. APA is only for transfer pricing, but it has been very successful. Last year also, India resolved 95 cases. And this year also, India is, the team which is there in APA, they are moving at a very good pace, and the target is to cross 100 this time. So not only in Asian Games, we want in APA also, ab ki baar 100 ke paar. So that is the target. And the next step would be that can we have APA type of mechanism in, non-TP area? That, we sit across the table and, resolve the disputes. Maybe more power is given to DRP. I think that is where we need to focus on, can we give more power to DIP to resolve cases? And and this is not, I am not saying that these discussions are going on, but I am quite confident that in future, these are the possible solutions for dispute resolution, and you will see either this step or some other steps in this direction to quickly resolve cases.
So I'll just add one point to what Mr. Kamlesh has said. See, this DRC is a very good concept, and the entire thing is done as far as CBDT is concerned. Only deployment of manpower is something which is pending. So for the smaller taxpayers, and in which small additions to the extent of rupees 10 lakh has been made, and income is below 50 lakh, in those cases, this dispute resolution committee, which is going to be a panel of 3 PCIT rank officers or CIT rank officers, 1 serving and 2 retired officers, that is going to be the kind of composition. And I think most of the smaller cases, it will work as a boon to those cases because people can go within 6 months, decisions would have to be delivered, and they can waive penalty and prosecution. So very noble and timely concept which has been brought out in the law by the CBDT.
But once again, Dhiren,
Bar also, DI also, something like that cannot be brought into bar because DI will form in 19. Now it's still like no as such.
You see, bar or earlier AAR, this is a very noble concept and came to India through global conventions and G20 decisions, etc. Somehow the pace of disposal of cases has been a problem, probably because of staffing issues and all that. So now the structure is sort of settled, though there are only 3 benches as of now. So I think disposal of cases should pick up, and that huge pendency as of now. Probably the government may think about expanding BAR, seeing the pendency, etc. So I don't know what is the discussion, but things should start happening now. That is my hope.
Issues are that AR and bar are pending since 15 or
I know, there has been a lot of time.
assessments and etc. are also pending. So we have to find some.
No, the board and the government must be concerned, and I think they are seized with these matters. And as I'm saying now, structure is in place, and probably staffing is in place. So, quickly the decisions should start coming in, and once decisions start flowing in due course, depending upon the requirement, pendency, etc. Maybe further expansion, because this is one very noble concept for certainty, and government is for certainty in taxes. So the kind of BAR, then you see reopening provisions, which the government has taken a call on, and creation of 100 posts of Joint Commissioner Appeal. These are all good things to reduce litigation and litigation faster, and to keep it under check, etc.
Thank you, sir.
Moving to you,
just one last sentence before we move on to the different topic. My question was, and still remains unanswered, as to how remodeling of the AAR to bar helps the faster tax certainty. Now these are appealable orders. Now you have serving officers sitting there. Previously you had officers who were not in the department. What must have crossed your mind to think that no, we don't want outsiders to resolve the dispute. We want serving officers whose APAR is to be written by CBDT to take calls on these issues also. That's the one sentence only.
मेरे ख्याल से Mr. Kamlesh can respond to this question. He has spent a lot of time on CBDT. I'm not privy to this decision.
I will only duck that bouncer.
okay. So, thank you. So moving on, so the question to you, Dhiren, as a senior tax professional in a very big conglomerate in India, and we all talked about tax reforms in administration. Pratap sir has released a book also, which obviously all of us will go through, but the gist of that was laid out in the morning by Pratap sir. So, talking about some of these changes which have happened, let's say faceless assessment. So what has been your experience as a taxpayer in the sense that in the earlier part where there used to be physical assessment, where you used to represent before the authorities, your presentation of your documents, evidence, vis-a-vis in the faceless regime. What's been your experience?
Experience of faceless till date is so far really good. Practically, there's not much issues except some practical issues on software or filing of the information, etc. Sometimes issues in VC also. But practical experience is good when the factual errors, etc. are being accepted by the NFAC and good orders are being passed. But major concern is in case of a complicated issues. Currently, they have kept restructuring out of faceless. But when there are a lot of mergers, demergers, there are a lot of EPC contracts, 5 or 6 parties are involved. Contract size is say 500 page plus. To upload them, to explain them only on VC also. And that also VC is available only post show goes on only. So if we have some leeway to explain them in such a way, then this show cause also can be avoided and we can explain the facts in such a way that it can be understood by them also. I don't know how to solve this issue, but this is a big theoretical one.
See, very valid point by Mr. Dhiren. You see this faceless regime, whether it is assessment or appeal, was rolled out probably for the benefit of taxpayer and sort of like to bring transparency and accountability. So these are the objectives which government has said. But what is happening in, like, satisfaction level is really high. I would say that satisfaction level of the faceless regime is somewhere around 70, 75.
Really good, I agree with you.
80%. But in some of the cases, some big cases, it becomes really difficult for both the assessing officer as also for the SSE to communicate with each other, to put across his ideas and views. And this is the issue. Mahapatra sir is here, Akhilesh sir is also here. CBDT, like, naturally these issues must be in mind of CBDT as to what kind of mechanism we can evolve now. Faceless regime is settling. So something maybe in the bigger complicated cases, like you were saying, that some categories have been kept out of faceless regime. So maybe something similar kind of structure, but I really don't know what is the exactly thought process at the CBDT and government level. But 2-3 things I would like to say in the faceless regime, which we have faced and seen over a period of time. One is compliance label. So there is some problem with the compliance label. Like we end up doing, now it is part of stats, 30-35%, maybe at times more also, cases in ex parte basis. So we are not getting responses from the people. So maybe either that email is old, or the person whose email was there, he left the organization, or the chartered accountant whose email was there, he was no more working for the SSE. So we are trying our best, but still within the existing mechanism, we are not able to find much solution. Like the person left the place of physically also, in few cases our people can go and visit the address. But if the person is moved and the time barring date being closer, it becomes a bit difficult. So it's true that bigger cases, filing submissions, and for officers also, to go through submissions, if it is 100, 500, 1000 page submissions,
you also
or
can't download,
huge,
you also can't
huge
print and all
contract.
that.
So going through the relevant clauses, we can always ask, bhai, wo cheez kahan pe hai isme?
Correct.
and the person across the table can always explain. Maybe video conferencing system can be made little more broad-based, because as of now the government feels that physical discussion or meeting is not advisable, because there is a kind of future we are moving towards. So we need to make the existing systems better and better, but I feel it may take a bit of time.
So major issue is timelines also, because we have practically seen that show cause is being issued, then we need to file the submission in a day or two only. And sometimes in a big show cause, it will take time. So if NFAC can start the assessment in advance, and then enough time can be granted to the SEC, the same will help, definitely help.
I share your concern, Mr. Dhiren. But see, what happens if you see my experience, and I'm not saying for this year, I'm saying it over last 3 years. When we issue the first show cause, again it is like first notice or questionnaire you say, only 5% to 10% people respond. And responding means that they are filing reply. Only this will include people filing reply, people seeking adjournment, etc. So I don't know what is the problem at the end of the SSC is that they respond very late. So let's say if the reply to the questionnaire is coming just a month before the time barring date, it becomes very difficult for the officer because he has to follow a certain procedure. Okay. He has to finish it off, maybe a reference to verification unit, and thereafter some minimum time is given for so cause, then this process of review, etc. The matter is to go to this CPC. So my request and advice to all of you, you're very, very important people and key stakeholders in the tax system, that please file your submissions, your reply on the first date. If not on the first date, maybe immediately thereafter, after 10, 15 days, take only reasonable period. And be specific. At times, like I raise 10 queries, the person is replying to 3 queries. Now, I'll give him further time, then further time. So it is happening both ways. So due course, I think this should stabilize. There should not be much problem. And the taxpayers, I agree, should get proper time. So from both the sides, from officer side, starting early is noble idea. And a request and appeal to the taxpayers not to take time and responding in complete and at one go.
Point taken, sir.
Thank you, sir. We are running short of time. Maybe 1 or 2 minutes. Any questions from the audience to any of the panelists?
There are 2 more sessions before lunch. Their lunch will get delayed.
Okay. Okay. Thank you, ladies and gentlemen, for I think this was a wonderful session. The wealth of knowledge that the panelists, the esteemed panelists have displayed is, I think, immense. The short point, the takeaway as I see from here is the substance over form, that is the norm. So whether it is the beneficial ownership word is mentioned in a particular article or not, any kind of structure that you put up, any business that you are aiming to align or realign, business and commercial rationale has to be at the center of it. And therefore, once you have the substance created, things would become much more easier as against just putting up a structure and then trying to claim a treaty benefit. Thank you very much. And on behalf of my firm, PriceWaterhouse thanks to the panelists and to TIOL Congress for this session. Thank you.
Thank you.
Thank you to all the panelists for a very engaging session. We request all of you to please come together for a group photograph. I request Anuj and Neha from TIOL to please join us on stage and present the panelists with a small token of appreciation. Can I have Anuj and Neha on stage, please? Where are Anuj and Neha? Come. Come. So if you could please stay back for a few minutes. Yeah, please go ahead. Anuj, you go in. Thank you, gentlemen. Thank you once again.